How are you beautiful tubers doing on this frigid? Oh my gosh, why is it so cold? Night. And I think my seat collapsed. I hate office chairs. I think that's why I'm so short. I'm like chizzy size right now. I think my chair went down. Hang on. So there's been a problem since I fell. There it goes. Whoa. How you doing? Hang on one more time. I have to wear pants because it's so cold. I don't like wearing pants. So cold. So cold here. My back hurts. Oh, yeah, I know why my back hurts. I was out shoveling snow today. When I say shovel, I meant blowing it. Did you guys see that? Hey, Tivo, how you doing? Shane, what's going on, man? Treasure Island, look at me being exactly on time, like always. You're opposite of tardy. What's that called? A party? Hey, Melissa Jane, how are you doing? Side eyes, Jess. Both expert. I hope this is fun time. Oh, I got in trouble for eating, by the way. Hey, Danielle, how you doing, babe? You've been out twice today. Kingdom Mountain. Look at you. You have. So, Fall Storm. He's got a Cybertruck. He can go anywhere. I think it goes right outside of buildings like Spider-Man. They shouldn't call it Cybertruck. They gotta call it Spider Truck. Uh-oh. There's trouble number one. Actually, I guess number two. I already said hi to Side Eyes. I'm really curious how it's going. How he's going to see this. What do you mean? What do you mean how I'm going to see it? I'm going to watch it with you. All right. How you doing? Oh, yeah, leave her the tail light fairy. That's a great term. So you know what? I got to say, this is the great thing. Hey, Debbie Joe, how are you doing? Daily Sports Highlights. What's going on? Christine Fortunato. Hey, babe, what's happening? Granny Debbie, how are you doing? Hey, Lost Souls, how are you doing? Guys, Lost Souls, if you ever need something to do, go check her out. She's got a cool little channel over there. Very chill, very hangout. She does a lot of true crime stuff. Is your show? If you want, oh, thank you. Every day's a no pants party. Yes, he has a pirate ship. It's unstoppable. It's the Black Pearl. Are you gonna get that Lego? The Black Pearl? Oh, insights. Yeah, so I woke up. Hey, Colleen, how you doing? I woke up when this was happening. Wait, hold on. I didn't tell him anything yet. No, I don't. I know nothing. So, hey, Miss Nomer, how are you doing? Such a beautiful avatar shot there, profile shot. Yeah, you do. You really do, man. You need it for the Jack Sparrow. Jesse merch is necessary. I'm glad you said that. I've got to get on my merch store and start updating stuff. There's so much. I've been saying it for 2 years, though. So, all right. So, one, I got in trouble with the eating the nerds. I'll put them down. It is so cold. My fingers are so frigid, y'all. So frigid. Anyway, so I did not see Turbo. It's so early. It's like 9:30 in the morning. And it interferes with my beauty sleep. So I isn't it though? The sunlight and all that stuff, it's a good picture. What was I saying? Oh yeah, this show. Hang on a second. I gotta find the thing. Oh, there it is. Ah, we're going to. I need to do that too. Where's his? Why did I do that first? I need to get crud. I hate the way I did this. So let me do this. So what we're going to do is we're going to play our friend, the Great Dane. He filmed it. And so we're going to use that, his filming feed as our watch it for the first time. And then, and so there, I'm putting his stuff right there because if you guys are not subscribed to Broken Baker, please do so. And it's gonna be his feed, and it's gonna be a live reaction. The only other thing I have to do. Look at this. I have a black and I have a black and yellow tub to clean off my desk, so I may be throwing things in here. I think I'm just gonna throw it all in there, and then take out what I think I want. Does that make sense? It doesn't to me. It doesn't at all. My fingers are so cold. How do you warm up your fingers? Hey, Mitchell, how you doing? What's happening here? Oh, baguette. See, I'm used to seeing corn. It messed me up there for a second. D-Rex, how's it going, man? The hearing is kind of wild. Oh, great. Guys, other than that, so what? Oh, yeah, that's what I was going to tell you earlier. I got so excited about. So if you see the short I did, well, hang on, I'll just show it to you. Let's watch this short. Why don't I self-promote? Wait a second, I'm not going to self-promote. I want you guys to go watch it. So which one is it? Why don't you go watch my short? I got the blower out, which, by the way, I think my wife has been in the garage at some point moving stuff around, and I think that she moved my nozzle. Because I'm like, I don't play with my nozzle. Like I have a short nozzle that I play with, but like the long one, okay, that's put away for special things. Like today would have been a good long nozzle day. And I was like, where is it? Like I'm pretty sure I put it right next to my chainsaw. And I couldn't find it. I asked her about it. She's like, she hadn't seen my nozzle. I'm like, you need to see my nozzle because I'm pretty sure you have it. Like, I'm pretty sure she has it last. I think she went in there. She was organizing stuff, and she doesn't realize like there are very few things in my life that are very specifically organized, and those things are like the batteries to the outdoor equipment, the nozzle next to the chainsaw. Like so like I'm like, there it is. I know I'm putting it there. I will not forget it. Blah blah blah. And then she goes out there and she makes everything look nice. And then I can't find things on my nozzle. If I had the nozzle, I think the looking for evidence against Karen Reed would have gone much better. But I had my short nozzle. So my stubby nozzle, okay, it's soft. It's a soft nozzle. You guys, I have a special nozzle for my blower, and it's soft, so that way, like if you bang it, it doesn't hurt. Like so, you like it's for like cars and stuff. Like you get on you get your car wet, right? And you use the blower to dry it. If you accidentally you get on the hood or something like that, the nozzle won't leave marks. It's a special nozzle. It's really cool. I'm so proud of it. But it didn't do the snow blowing as effectively as I thought it would. However, when I was doing that short, I was like, oh my gosh, like this really is. I gotta hand it. The Canton police, they taught me something. Blow the snow, and it's a go. Like, see, it kind of rhymes too. Like I just blowing that stuff everywhere. I was blowing it like it was blowing on the driveway, blowing it on the yard. I didn't need to blow it in the yard. I did that for the short, but like the driveway, the whole driveway's been blown. I think my neighbors made fun of me. I'm pretty sure they did. But let me tell you guys what, it is so cold here that I put salt out afterwards. And I had a shovel too. I shoveled a lot of stuff. But like you get down, there's a layer of ice on the bottom. I didn't want to mess with that ice. I blew all the snow off. There's ice down there. I got it. I scraped it all pretty good. And then I put salt out. The salt has not melted the ice yet. It's the effect of salt. Yeah, it's on the shorts. It's on the shorts. Hey, Dodo, how you doing? Oh, where's King Bob? I saw King Bob. I said, wait for a minute and come back to nozzle talk. Yeah, have you ever used a short nozzle? It's so much more useful. So much more useful. Yeah. I'm telling you, you gotta get Mad Max one. He'd love it. Well, I don't know if he cleans his car like that, but like it's really great. I was not mentally prepared for this day. Oh, we're okay. We'll be fine. We got it. Just relax. I hate when I go get ice. When I get ice in my nostrils. Yes. Well, you know what though? It comes off. Camera off. All gone. All right. It's just me. Oh, yeah. You guys see this? Look at that German Shepherd. Oh, my gosh. I'm here. Different phone. Different profile pic. Depends on when you're using a short nozzle. What you're using a short nozzle. I could use the long nozzle today. Oh, I got a big head. I had it out, and it will fit on the short nozzle. But it doesn't. I didn't like the way it is. I didn't like the big head. Like it's. I feel like it didn't get a strong enough blow. Does that make sense? The air, the shooting out the air stuff. I mean, the air. It's not stuff. It's air. I mean, you know what I'm talking about? The snow. Yeah, it does. And that happened to Brown Dog today. I hear this little whimper. I hear and I'm like, so I drop everything, right? And I'm like, Bud, where are you? And I look, and he's on the front porch. He's got a little back paw. Oh my gosh. And so I did everything perfectly right. I ran to the door through the ice and snow. I was like a mailman. Couldn't stop me. And I run to the door. And I open it up and go, honey, Brown needs you. And she got him inside, and she found out that he had snow impacted in his paw. And she had to hold his paw until it got warm. And then he wasn't limping anymore. I kid you not. You don't think that Labrador is spoiled, do you? What a I almost said what a dodo because I saw you say dodo. Oh my gosh, that's so funny. Hey Dodo, did I say hi to you? Sumo, how you doing? I think a flamethrower. Let me tell you what, Sue. I almost went and got the flame. I almost went and got the flamethrower. I really think I need to use it on the steps. Would you guys like a video of that? It would be cool. This is a small one. It's a small blower, flamethrower. It shoots out. I mean, it shoots out. You love how I'm telling you, like, how big do you think this is? I don't know because I don't know what size screen you got. Like, it's like that big of a flame. Might be that big. I mean, it's just, oh, yeah. Oh, was it? Love it? Spoiled. Oh, it was so sad. She did, and I didn't know that because when I finally came in, I was like, oh, I was like, how's Brown Dog? And she's like, well, he's doing just fine. And I was like, okay. And that's what she told me. She held his paw in her hand until it warmed up. And then hey, how you doing there, Zach? I almost called you Zeke. Zeke would be a good name for you. Expert local news showed a guy burned his house roof for the torch. Yeah, but you don't do that. You do it on the driveway. Let me tell you what, that guy was no flaming expert. I'm a flamer. Okay. I've gotten in trouble for that before. Had the fire department come. They showed up. It was bad. It's like they told me I needed to move to gasoline. The fireman coming is part of the reason why I have an electric lawnmower. It's electric, battery, it's battery powered. Because they told me they didn't like my gasoline situation. I was like, why? What's wrong with it? And they said, what? There's rags hanging out of the. I'm like, well, one, I'm from Tennessee. Okay. I'm pretty sure like everybody in Tennessee has a rag sticking out of their gas can, because how's you going to stop it from the gas coming out, when you lose the little nozzle or whatever. But no, it's one of those little hippie ones. Have you guys seen those hippie gas? Oh, I hate those damn things. We're going to say some bureaucrat sitting at a desk who's never mowed before in their life came up with the idea that gas fumes, the freaking fumes, are what's destroying the entire planet. So the new gas cans, and here's the truth of it. The truth of it is they wanted to sell all new gas cans. And so the gas can lobbied for this environmental crap. And so now it has a little flipper in there, so the fumes won't come out. Well, guess what? It doesn't bring any gas out either, and the gas just pours. It doesn't go in the hole. It's like a guard hose. Just gas goes everywhere. I got more. I got a 5-gallon can, 3 gallons around the yard where it's run off the driveway. So I ripped it out. I got some pliers and I ripped the hippie innards out. And but then to stop it, from leaking, I put a paper towel in the end. And the fireman didn't like that. Saw that, and he's like, "It's not very fire safe. Fire safe. Chaos queen. I think chaos. We found chaos. I think we found chaos. Still safer than a rag. What's a rag? What is? Hey, She-Huns, how you doing? What? Them? Number one cause of house fires, rags next to paint cans. I can't even deal with gas rags. Who has paint cans that's sitting around? Well, when you're done huffing them, they're gone, right? No, don't huff paint, y'all. That's the serious. You're really messed up if you do that. It's really bad. It's so bad. Wait, hold on. Are you guys seriously? You don't. Come on, somebody back me up here on this. You put a rag in the end of it. I don't have a cork. You used to be able to get corks. Huff canned air. Darn. You know how bad huffing is for you? Oh my gosh. Do you know that? What was it? What's this nitrous stuff? Oh yeah. That stuff, man. Oh, I watched a whole history on that. The guy who discovered the gas, he's like, well, this is a magical gas. I feel so good. And he started inviting other people over. But seriously, it's like the whole scientific community in 1820 or whatever it was is all hanging out after the labs closed, and they're all getting high. Well, I feel so euphoric. I've all these weird things. And then the guy that discovered it, he died like 45. What an idiot. Don't do that. Don't huff gas. Only gas you're supposed to huff is oxygen. For a while, we cannot use canned air in the Army because a full bird colonel found dead from hunger. A full-blown colonel. What? Oh, that's not good. That's bad. Wait, hold on. I wonder if it's just you. What? That has your gas can stopper as a rank. I don't have it anymore. I don't have it anymore. And I have battery powered. Yes, I do have 5 gallons of gas sitting in the garage for no particular reason. But don't worry, though. It's in a new container. It's in a made in the USA racing container. So it's for off-road use only. I just realized how bad that sounds. It's legit. It's safe. Okay, so what we're gonna do tonight is we're gonna go over this. I didn't get to see this when it happened. I was getting my beauty rest. Oh, thank goodness, there it is. Boy, I couldn't find that. Oh, that's a new tab. Why? All right, where'd this go? All right, so I got Baker stuff. I saved it. There we go. We're gonna do. So I got this. I did see part of this last night. And it was, I mean, I saw this part of it because Side Eyes told me, you got to check this out. And so Marissa sent that card to him. She got recorded her voice on a card and sent it to him. And that's very nice of her. Very nice of her. Hey, CJ, how you doing? Canned air propellant is bad. Very bad, Mitchell. It's very bad. That sounds makes you cuckoo. All right, let's see here. So where do I go to start this thing? Where is he? Okay, that looks like they're walking into the courtroom. Let's make this bigger. There we go. Look at that. They sit down. Let's see here.
Yeah, he was streaming just before we went live.
Boy, it's so bad hearing Baker's sick, isn't it?
Broadcast. If you are not qualified under SJC rules.
Okay.
Honorable court in session, please be seated.
Please
Morning,
be seated.
before the court, matter of Commonwealth versus A. Carney on Norfolk dockets 2382 CR 00313 and 2582 CR 0088. Mr. Carney is present. So please identify themselves for the record, beginning with the Commonwealth.
Good morning, Your Honor. I'm Robert Cosgrove.
Good morning, Attorney
All right,
Cosgrove.
that's the attorney.
Good morning, Your Honor. Timothy Bradle on behalf of Aiden
Oh,
Carney.
look at that.
Good morning, Mr. Cosgrove. Mr. Bradle.
Before Mr. Carney, Mark Federer. Good morning, Your
Good
Honor.
morning, Mr. Federer.
Let's scoot up a little bit here.
A motion to be supported by a memorandum of law.
Okay, I already have a problem here. What? Why is this? Is this who's filming this? Is this the court's filming this? Is this what the court does? You strutted your behind in there? What? What happened? Where's this? Oh, well, hold on. Let's rewind. Let's rewind this then. Where are we going? Oh, I want to see the strut.
We are.
This strut.
Court, all rise, please.
Elfish, how are you doing? Man, you got some great merch. I saw Baker open all that stuff. No, don't rewind it. It's blurred.
Honorable court in session, please be seated.
Good morning, Your Honor.
Why
Before
didn't
the
you
court is the
strut?
matter of Commonwealth versus A. Carney on Norfolk dockets
All right, let's go back to where we were.
2382 CR
So here's my
003.
question.
Motion.
Who
To be supported by a memorandum of law.
is recording this? I probably should listen to what the rules are of the court. Hang on. I just realized that. But why is that sideways? Oh, Marissa, she has that voice on that card.
117 in part, 125 and 127. Those are the matters which deal with the request for the recusal or removal of Mr. Cosgrove as counsel for the
But they didn't
Commonwealth.
have
Now,
jurisdiction
before
over
we
me.
begin that, particularly Mr. Pedro, just to you, and I know Judge Dolan may have talked to you about this a little bit. Going forward, We don't file affidavits as motions. Rule 13 requires a motion to be a motion. It can be supported by a memorandum of law, can be supported by an affidavit. The matter we're here for today, there is in fact no motion on file. I'll take it as it sits because it's been responded to. But going forward, if you want to file a motion, it has to be a motion. It has to be clearly captioned as to what you're looking for.
Oh man, I'm already feel doomed. Golly. Okay, so he starts off with saying you didn't do a motion, but it got responded to. So the Cosgrove response that was 2 weeks late and all the other stuff. So get this. Wouldn't it be that if there was no answer to the Bedro filing, that what the judge just said, there would be no motion. So the whole thing would be mute if he hadn't responded. The whole thing would be mute and it would be going forward as if that 88 pages were never written. Wow. Wow. Further, it has to deal with one subject at a time. I'm not going to do motions that deal with the entire kitchen sink. Now I did. Okay, so I don't know. I was going to say, so like, I'm used to like motions seeing like one at a time, right? Like it's usually one big thing. But this didn't feel like a motion either. It felt more like a table of contents for what was inside. Like the what was like a table of contents for everything that's going on. I just feel sick. I don't want to see anymore. Be clearly noted. If you want to put a memorandum of law, again, you have to reference the motion you're dealing with. Further, if you want to put an affidavit, the affidavit has to reference the motion that you filed. If you want to put in a supplemental motion or a supplemental memorandum, it has to list the paper number that you're talking about. Going through this over the last several days and trying to figure out what I'm dealing with took an amount of time, which now come on, I figured that out because I'm trying to trace back what you're talking about, and I can't find the motion because it doesn't exist. So I understand you're not local to Massachusetts. Mr. Bradley is extremely experienced and quite good at drafting these things. So,
because I was going to say that's my fault. I'm local counsel. I should have made sure that was that way, and we'll make sure that going forward.
And I note that paper number 127 is more in the form that we used to in this court. So I just want to remind everybody where we're at. And again, not familiar with the area. That's okay. Just going forward, I don't want to have to sort of parse through what we're dealing with, nor do I want to have to hear from Mr. Cosgrove saying there's no motion filed, because it's a pretty good point on his part. So with that, let's take up the matters that are before the court. You're the moving party. I don't know who wants to argue, Mr. Bradley or Mr. Bedro.
Mr. Bedro, you're
I like it.
We'll hear from you.
I'm going to complain. I don't like it. I'm nervous.
I've looked at all your motions, as well as all of the exhibits.
May I, Your Honor?
You may.
Counsel states that a recent conflict of interest has developed
that how you doing?
Precludes him from continuing to prosecute matters in which Lindsay Gaetani is an alleged victim or party. Those are the words of Mr. Cosgrove on September 24th, 2025, regarding his request to be removed from another indictment in which Lindsay Gaetani was a witness, and we'll get to in this argument why she may very well be a witness in this case.
Witness is different from victim, correct?
I'm sorry?
Witness is different from victim, right?
Of course. But as we'll get to, Your Honor, if a prosecutor or anyone has a personal interest that may differ from Commonwealth's or to a defendant's right to a fair trial, that's something that has to be factored in. The point of that comment, Your Honor, is that Mr. Cosgrove acknowledged that there was a conflict arising out of Ms. Gaetani's claims against him. She has accused him of unprofessional and unethical conduct and has sued him. He draws the line.
I note that the last docket entry in that case was in the process of being settled. That's paper number 15 on that case that was filed just last week.
Judge, whether the civil case continues or not, isn't even necessarily the issue.
Explain why that would not be a problem.
Because she has accused him, a lawyer, a former judge, of unethical behavior, and he has a personal interest, understandably so, in defending himself against that.
Did I miss the beginning? What did the judge call this? Is this a hearing? Like, what's the official title of this court proceeding?
And in any matter in which her credibility becomes an issue, as she testifies in a trial, he has an interest in discrediting her, which may be very different from the Commonwealth's interest, which I'll get into as to why that may be. But the point is calling her an alleged victim and that there is a conflict because of her allegations against me, merely being a witness in a case in which she may testify, as the difference which somehow makes his personal interest, acting both as a criminal prosecutor while serving as a civil defendant and potentially cross-examining your civil accuser and your lead detective, is a civil co-defendant who has also been accused of misconduct, undermines the public confidence in the proceedings and demonstrates that a prosecutor could have a personal interest. The bottom line, Your Honor, the difference between witness and alleged victim is a distinction without a difference if the prosecutor has a personal interest which could significantly impact his representation of a party in the case. That's the Rule 1.7 issue. Now, Mr. Cosgrove has replied that, well, we're not going to call Ms. Gaetani as a witness, and that certainly is right for the time being anyway, as the prosecutor for the Commonwealth. But the defense may very well call her. Her credibility will be an issue, obviously, if she testifies in this case. At that point, having a prosecutor who has been accused of misconduct, who is named as a civil defendant, attacking her credibility and attempting to defend the credibility of other witnesses whose credibility could be impeached by Ms. Gaetani is a problem. It's a problem because the jury would have a right to know what the prosecutor's interest may be. It's not...
Well, he chose not to cross-examine her.
That's a decision that has to be made by a disinterested prosecutor.
Oh, that doesn't matter. Well, how would you say... man, judge, I mean, okay, that's the judge is waiting, okay? But you have a right to cross-examine. So why would you say, what if you don't? I mean, that's it's prior restraint. All right.
What if you got someone else to cross-examine her?
That may or may not solve the problem. Certainly,
it has a crooked letter in it.
The direct examination of her.
But he's not going to call her. He's made that clear.
I understand that. What I'm suggesting to the court is we may very well do that.
You may, and you'd have to get permission from the court to do that because you'd have to show me that it's relevant, but that's another issue down the road.
Well, I'm going to tell you right now, respectfully, why it may be relevant beyond just the substance of her testimony. Mr. Cosgrove addressed the substance of her testimony as it relates to the allegations against Mr. Carney. She also may very well be a witness who can expose bias of other important prosecution witnesses, who could expose conduct on behalf of some of those important prosecution witnesses, conduct which is not at all consistent.
Well, let's get to the nub of it, all right? Because I've read all your materials, so you don't need to repeat the argument to me. Look, as I understand the issue here, Ms. Gaetani, that's the correct pronunciation, yes, is it not? Ms. Gaetani has an interaction with Special Prosecutor Mello in December, I think the 24th, was it, or the 23rd?
Something like that.
Of 2023. Mm-hmm. It's around that time that she's alleged to have some interaction with Ms. McCabe. Is that correct?
Among other times, yes.
Well, around that time is my understanding, based on the evidence you presented me. Around that time, Ms. McCabe urges her to go to the grand jury. Do the right thing, go to the grand jury, something along those lines. All right, is that correct?
In substance, but I think it's interpretational, and the witness might expand upon that.
I understand that. All of those events occurred 6 months after the events that are in play here. So the relevance of those events is only as to the credibility, potentially, of Ms. McCabe. Now, you might be able to get into that. You might be able to even confront Ms. McCabe. But then you're going to have to raise an issue of whether or not you get into a trial within a trial, so to speak, the extrinsic evidence rule, which takes us to whether or not she is even going to be a witness to talk about potential bias after the fact. This is after the fact bias.
Yeah.
On an issue which, frankly, I'm struggling with a little bit, because nobody contests the acts here, all right? Mr. Carney is a citizen journalist, sort of a new breed of journalists, correct? He presents...
All right, hang on. Before we get too lost here, because I just saw a comment here. Where'd he go? Sumo, the term hot bench. I'm going to, because it's much better than I can describe it. This is a link. The SCOTUS blogs are a good place. I do like this, and they will explain to you. It's an interesting read. So hot bench is Supreme Court does it, appellate courts do it, and it's so let's say it's a case, whatever your case is. And I'm staying up there like, Your Honor, today we're here on appeals because my defendant feels like their First Amendment rights were violated under Bradshaw, or was it? Yeah, Bradshaw v. Ohio, whatever. I can't remember right now. Sorry. And then the judge jumps in and cuts you off and just says, well, what about this? And they just keep going and going and going. Recently in the news was it Alito asked a lawyer, I forget who it was for, but he said, what's the definition of a man? I said, well, I can't give you a definition of a man. I said, what's the definition of a woman? I can't give you a definition of a woman. I said, well, you can't define what a man or a woman is, then how are we supposed to rule on transgenders in sports? And it was just like, oh, it was one of those moments. Like, that's what a hot bench, it is terrifying. It is absolutely terrifying. I was I was in school still, and I sat second chair with a friend of mine who's an attorney in Sixth Circuit, and I was like, oh, this is stupid. No, I'm out of here, man. I'm not doing this stuff. Like, this sucks. Like, it was a very terrifying experience. But anyway, they make you look dumb in a hurry. And the best thing for an attorney to say is, Your Honor, I don't have an answer for that right now. I'll be happy to provide you with one in a couple of days. So that you file an answer, Anyway, sorry about that. So that's a hot bench. That's what you see what's going on right here. I don't understand why it's at this level. I've never even heard of it at this level. If you guys follow that link I put in the chat, it talks about the rise of it and whether or not it's good or not. You can make your own decision based on that. So anyway, sorry, guys.
To this court, that all of his activities are fully protected under the First Amendment. Very reasonable argument. Okay? Mr. Cosgrove says different. He says this is witness intimidation. The motivation of Ms. McCabe to his acts is tangential by and large, is it not?
Judge,
now she's going to testify, yes, I was intimidated. But the main factor here is the nature of the comment, which is recorded, made voluntarily and recorded. Now, you are correct. There's an excellent argument to be made, perhaps, that Gaetani and Genduso and McCabe may have all had some idea that they were going to get together and get his bail revoked. But that's not what this trial's about. This trial's about what happened 6 months before. So you got to draw me to the relevance of that.
Well, her bias and motive against him, whether before, during, or after, I would suggest is certainly relevant. Moreover,
it's all after. There's no before.
Judge, you mentioned a moment ago about the fact that she's going to come in and say, I felt intimidated or I was emotionally harmed. I think
you don't know
we
that.
would all agree that would be relevant about what the impact that these horrible allegations had on her. There will be evidence through electronic communications between Gaetani and McCabe, which Gaetani may very well have to authenticate as a witness, because frankly, we don't assume or take any guess what Ms. McCabe will say, where shortly after Mr. Carney was released from jail, from what Your Honor just spoke about, where Ms. McCabe recruited Ms. Gaetani and orchestrated surveilling him from various police stations and to other locations, joking about going on a stakeout. In other words, conduct not consistent with her being intimidated. Those actions will also
the intimidation doesn't have to last forever. The intimidation, we're only trying one slice in time. That's the bedrock of any criminal defendant, right? But not trying his entire life, we're trying that moment.
But these are questions that have to be posed to Ms. McCabe, and she'll have and should be forced to answer them and explain them.
I don't necessarily agree with that.
Okay, so the point is we don't know what Ms. McCabe will say.
Yeah, you have no idea until you ask.
Upon messages that we've seen, which would need to be authenticated, presumably what Ms. Gaetani will say about these issues.
We need to bring her
to move with time from poll to poll, correct?
I'm not sure what you mean.
It seems like her allegiances have changed as this case has developed.
She is, without question, a unique witness, which raises another interesting point, which could lead to the possible conflict with Mr. Cosgrove. She is a former prosecution witness. There's no question. She testified in grand jury. She testified at a trial called and vouched for by Mr. Cosgrove.
Quite enthusiastically, as I understand.
I believe so, Judge. No question. And at that point, they had no problem with Ms. Gaetani. But at this point, she's now sued Mr. Cosgrove. She has sued Tully. She has threatened to sue or sent a demand letter to the DA's office. And when that happened, Mr. Cosgrove said, I have a conflict with her because he has a personal interest in seeing her discredited. And I'm going back to what I first started with, Your Honor. The issue is not because she's an alleged victim. She's a potential witness in this case, and the prosecutor has a personal interest in seeing her discredited. And the critical part comes in the argument to the jury at the end of the trial. When McCabe has testified, it's in Mr. Cosgrove's personal interest that she be credited, Gaetani not be credited. When Tully testifies, it's the same exercise. He's a co-defendant of his.
What's Tully going to testify to?
Is Tully going to testify? We're not calling Tully.
Mr. Cosgrove, what's Tully going to testify?
The judge says, what's he going to testify to? You know what in my brain? Well, I don't know, Judge. Why don't you tell me? You've been telling me what everybody else is going to testify to. Sorry.
Testify to? Is he even a witness?
I haven't made a determination as to whether I'm going to call Lieutenant Tully or whether I'll need to call.
That's a good answer.
Lieutenant Tully.
I made that determination. What we're here for today is whether or not I should be kicked off this case, which I already said I would leave.
Himself made public, documenting his statements and actions are pretty much self-authenticating. I'm not sure.
Well, I think you may have to make a choice here fairly quick if we're going to deal with this issue. But continue.
Look, the bottom line is Detective Lieutenant Tully is the lead investigator on this matter. Now, that doesn't obligate the Commonwealth to call him, but he is the driving force behind this. He built the investigation. He got the search warrant.
This is not your classic whodunit.
No.
This is not the investigation where they find evidence on a scene. They develop the evidence on the scene.
I think they did develop the evidence on the scene, Your Honor.
Phone downloads. They do this, that, the other. This is a very unique set of facts. Where the defendant recorded himself and then voluntarily broadcast his actions to the world at large.
Yeah.
So the investigation essentially
Thank you for finding that.
Record, and then a jury of his peers, all right, would judge the mores of our society to determine whether or not this is acceptable First Amendment or not acceptable First Amendment.
The point
I think while you're going down that path, Your Honor, this is a perfect opportunity for you to rule in our favor because you know that he is going down the path of the First Amendment. It's between personal free speech, between the freedom of the press. He's wrapped in the American flag of First Amendment. Go ahead and dismiss in our favor. We'll appreciate you. We'll call it a day.
Making, Your Honor, is that Tully.
And I would like the jury of peers to make that decision. I don't want to make it. I want the jury of his peers to make
That's
that
lead the judge right there. He says, I don't want to make it.
Your
Oh my
Honor,
gosh.
On this issue, is that Tully
Yes!
is the lead investigator.
Hey, Strains,
And
how's it
certainly
going?
I can only speak from my own experience, perhaps others, that it would be extraordinarily rare not to call.
I don't find that to be accurate in my experience. I've seen it happen a number of times,
I've
much
seen it
to
happen.
my disappointment when I sat over there. Okay?
I've seen it happen, and I've taken that from the other side of the table in prosecuting rather than defending, in letting juries know who built the case, what is going on here. But the point,
And fairly pointed out by the defense, and you didn't hear from him.
it could be. It may very well be, but
Wait a second. Have juries ever ruled on constitutional rights? I mean, you don't read cases about that. Juries don't rule on constitutional. Is this going to be a jury trial? I mean, if what you're bringing right now is constitutional right, I mean, that's always done in front of a judge. Juries don't do that. Juries aren't constitutional scholars. That's no offense, but why would you let a jury pool answer that question? I mean, look at, we have people that think that it's unconstitutional to pay your income taxes. We have people think it's unconstitutional to have a driver's license. We have a lot of sovereign citizens out there. They're all these are beautiful people that have beautiful, great concepts and stuff, but it doesn't mean they're not they are trained constitutional scholars like judges should be. I don't think I've ever heard of a jury answering a constitutional question, unless you want to consider stuff like, every criminal question is constitutional in a way.
that could also lead to the reason why. Okay, the issues surrounding Gaetani's claims. The defense wants to argue they're not calling Tully. Perhaps the jury may be entitled, not asking Your Honor to make evidentiary rulings now, obviously, but the jury may want to know and be entitled to know, why isn't the prosecutor calling him? And might it have something to do with what Gaetani alleges? But moving away from Tully to the larger point, it's not even so much the cross-examinations, or other evidence, which I would suggest are.
She-Hans, thank you so much for the super sticker. Let's not forget why we are all here.
Wiggle, 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 yeah. 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 Wiggle, 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 yeah.
Thank you, She-Hunts. Also, hang on a second here. What was I want to say? I don't trust a jury, not smart guy. Jury. Don't say that, Mitchell. You want jury duty. You want it. It's a wonderful constitutional right. And if people like you don't do it, look at the people that will. You've got to do it. Y'all, if you ever get called with jury duty, please take that so serious. It is the most wonderful thing you could ever. It's the greatest duty is serving on a jury is more important than voting for president of the United States, in my mind. It's amazing. Yeah, I'm not saying that I want that responsibility, but it's amazing to think, if you're there on a murder case, for instance, you're seeing, well, I mean, heck, look at this. They're talking about sending a guy to jail for the rest of his life for posting stuff on the internet. I mean, this is a judge that thinks you can't restream public hearings in the courtroom. I don't think he understands what restreaming is, though. I think he meant something different. I mean, this is. Oh man, there's so. Sorry, my mind started going off from the constitutional stuff back into this judge. You just told me how I just hit a loophole. Sorry.
Being conducted by a prosecutor with a personal interest in favoring certain witnesses over the one that is suing him. It's the summations, it's the argument. If Mr. Cosgrove has an opportunity to cross-examine Ms. Gaetani, assuming he does, as Your Honor noted, maybe he won't, but I would suggest, again, that's a decision to be made by a disinterested prosecutor, not one with a personal interest.
Well, let's define the
You
personal
denied
interest.
that right to serve on
It is,
on a jury?
anybody can bring a lawsuit against anybody, all right? You know, the actions that are alleged here by Mr. Cosgrove, and most of them appear, frankly, seem to have occurred prior to his arrival in the case. But the actions are alleged were done solely in his role as a special prosecutor. You know, his immunity is almost impenetrable, correct?
In a legal sense.
Sir, this is a legal setting.
No, Your Honor, my point is this. Personal interests don't rise and fall. They're not black and white because you've been sued or not sued. She has publicly and loudly accused a distinguished prosecutor of misconduct that he himself recognized after the lawsuit was filed. With this lawsuit that we're saying has no merit, what did he do? He sought removal because I'm ethically precluded from cross-examining her. It's the same issue.
Well, I'm not sure about that. I'm not sure what he said, but
He said that. I read it.
Well, Judge, I just want the record to be clear. What he said was, counsel states that a recent conflict of interest has developed which ethically precludes him from continuing to prosecute matters when Gaetani is an alleged victim or party, and we talked about whether we use alleged victim or witness as the issue. The point is...
Well, that's why I said that's not exactly what he said. What he said was...
Yes. No, I'm not trying to substitute that. We're trying to, in my view, suggest it's a distinction without a difference, because he has been attacked. And when he withdrew from the other case, the lawsuit against him was no better or no worse than it is now. So he didn't make that argument back then to say, this is some garbage lawsuit, I have no real conflict. What he said was, I am ethically precluded.
All right, I take your point. Mr. Cosgrove, if you're ethically precluded from one, why aren't you ethically precluded from two? I'll come back to this issue of the 2025 investigation too.
I reserve my answer on that.
Reserve it for when?
When it's my turn to speak.
I was about to give you your turn to speak, but I'll go back to Mr. Bedero. Let's talk about the 2025 investigation.
Your Honor, can I make one point I didn't get to? We kind of got. It's the summations where the real problem arises here. Because if Gaetani were cross-examined by Mr. Cosgrove, in essence, it is almost a free deposition. It is sworn testimony of her by a litigant against another litigant in a civil matter in which he has the full power of the government cross-examining, which will benefit his personal interest. Then you go to summation.
Oh, that's a good point.
Presumably, his argument will be Gaetani is not believable, Gaetani is not credible, but McCabe is. Now, those are appropriate arguments by most people to make, not him, because it is in his personal interest, not just as a representative of the Commonwealth. It is in his personal interest that she be discredited. And the jury should know that. Now, I'm not saying that's an appropriate outcome either. The appropriate outcome is that he be removed, because if he's vouching for the credibility, not in an illegal sense, but advocating for the jury to adopt.
I mean, I'm sorry, but like, just that's one statement right there. Look, it's easier just to remove him. There's a whole office over there of prosecutors. Just have somebody else come in. I mean, at this point, the best value for the taxpayer is just removing. Next. That's easy. Okay, well, that was easy. This is Zach says. Oh, what you think of the guy's name? I had a great joke, Zach. I had a great one, man. Oh, I screwed it up. Oh, yeah, this is what Zach says. Zach says Max Velocity is a staunch supporter of Turtleboy. I couldn't think of Max Velocity, man. I've had him on all day. I didn't know there were so many live cams in Tennessee. All right, so Ryan Hall is a staunch supporter of Turtleboy, minimum. Velveeta, on the other hand. I like Velveeta, man. I like that. His best friends with this judge and Meatball Morrissey. Meatball Morrissey, wasn't that a movie with Bill Murray in it? And then for Zach, we don't play anything because that's what he likes it. He is the entertainment. Oh my gosh. Do we get, hang on, did I see somebody else come in? Hey Latte, how you doing? All right, hang on. Let me get going.
Jen McCabe and discredit Lindsay Gaetani, the jury should not be ignorant to the fact that this guy's getting sued and wants her to be discredited. That is not the kind of thing that the public can have confidence in when they find out that the prosecutor who is judging everyone's credibility is discrediting her, crediting another.
Yes.
And it's tantamount to him giving unsworn testimony.
This goes back to the issue of relevance that we talked about before. And this is where I'm a little bit hung up. What McCabe does 6, 8, 10 months after the allegations here, because the allegations with regard to McCabe, as I can tell, they occur on 6/6, 9/20, and 7/22. Those are the 3 dates where she's alleged to have been intimidated. So
that sounds dirty, doesn't it?
So none of these matters involving Gaetani develop until perhaps December, right?
Gaetani's, some of her testimony, though, Judge, will corroborate other evidence we have of Jen McCabe's pattern of surveilling Mr. Carney before he was indicted.
But when?
In 2023, July of 2023. We have documented evidence of her, the intimidated and emotionally harmed witness, contacting Mr. Carney on social media and alluding to the fact, I know where you are, which is exactly what we're talking about with Gaetani.
That's a fair point to cross-examine her on. No doubt.
Don't know what she's going to say. From our perspective, having seen some of her other testimony and other proceedings, we don't just assume that she's going to be forthright. And we have a right. She's the star witness of this case.
I may need to know a little bit more about that. In terms of, if you want to file something and pound it to me, that's fine.
The final point I'll make, to Your Honor, before you have any other questions, is it's important that we're raising this now. This is well before trial. The prosecution is clearly on notice. I don't know where this may lead to, what else could be discovered. You know, this is a unique case,
sounds like a date.
And evidence is discovered in all kinds of odd ways, believe me, with how these cases proceed and who shares what and those kinds of things. It's critical for us to make this record now, alert the court respectfully.
I have no issue with you making a record.
Because if it comes up later after a jury is impaneled, there is a risk of a mistrial, and that will not be our fault. And we think at that point,
listen, Mr. Bitter, I have no issue with you bringing the motion. You need to advocate for your client in any way you think is appropriate. I'm just trying to flesh it out here, so I understand exactly what the issues are. I'm struggling with the relevance issues. You may have to give me more information on that, so I understand it a little bit better. Because the way I read things, they're much later in time. Now, if you've got something that's more contemporaneous to the alleged intimidation, I think that's very, very relevant. And would have to sort of play out how that would come in and what the form of that evidence. So we'll come back to that at some point when you're ready to talk to me about that. But talk to me about this. Your motion had three parts. Your affidavit had three parts, and one was the 2024. That's moot because it's already been done. The second was this issue. The third was this idea that I could preclude the executive branch from investigating things in 2025. Can you give me some authority which says I have the ability to do that?
It's a unique situation, Your Honor. I'm not going to sit here and tell you that there is a case law roadmap to what's happening, but what's important to recognize here, you've been asking us these questions about how is Gaetani relevant. She is extraordinarily relevant to what we're calling the 2025 investigation, which results in the search warrants for the phones of Karen Reed.
Which is still pending with Judge Krupp.
Right.
Let me play that out two ways. What if Judge Krupp says he can have access to the phones? Then we're going to have a much longer issue, correct? Is that going to come into this case?
Well, they're telling us that two people are under investigation. I mean, it's hard for us to know, right? I mean, they're attempting allegedly to indict Mr. Carney and Karen Reed for.
I want to interrupt this for a second. I spent a lot of time doing this like YouTube stuff, right? And so I have earbuds in all the time. Right now, the thing I picked up most is that the judge has brought it down a notch, and Bedrose brought it down a notch. Bedrose sounds more calm, more sure, and the judge is being less like provocative sounding. I know it may sound weird to you guys, like it's just something I noticed, so I thought I'd share it with you. But it's in a hot bench thing like this, the attorney's never prepared. I mean, I'll just tell you that. Like, I don't know, maybe some are, but it's just like anybody I've ever talked to, anyone who I've ever watched some of that, it's nerve wracking because you don't know. There's the judges, man. They're so good at making you look like an idiot. And you're sitting there going, "Are they trying to make me look like an idiot?" And I mean, I've seen some people that are judges now stand up there and get at a loss of words when you're just being hit like this. And judges, man, they got a great way of putting a gleam in their eye. It just makes you think like, oh, geez, I'm going to be told to leave this courtroom. All right, sorry.
Actions in which they already tried to indict and the grand jury said no. And now 2 years later with phones that have been gathering dust, we need to look in these phones and, God knows what we'll find. But the point is the search warrants in that case are critical and certainly could relate to evidence used against Mr. Carney. There are two informants in that search warrant. One of them is Lindsay Gaetani. And the affiant of that warrant is Detective Tully. And there are about 10 paragraphs, and I'm paraphrasing, I don't know the exact number. I
read the warrants.
Relying on her, and it is loaded with information which she provided them, and we're back to the personal interest of Mr. Cosgrove. So that really was meant to just inform the court that this is a living, breathing issue.
I will agree with you, it's a living, breathing issue. It's just not a living, breathing issue over which I have authority.
Fair enough.
When that comes to me, if it comes to me, I don't know if my special assignment encompasses that. We'll see. But if it comes to me, then we'll deal with that issue. I can find nothing which gives me the authority to restrict that activity. Judge Krupp has the authority on the search warrants, and he'll make a decision in due time. But I find nothing which gives me the authority to restrict prospectively an investigation that's being done by the executive branch.
Judge, just before I sit down, and unless the court has any other questions, I just want to correct one last thing. Your Honor had mentioned about a lawsuit being settled. That is not the lawsuit involving Mr. Cosgrove. There's no...
Sure it is. I looked at the docket this morning.
Not with him. That's with other parties to the litigation, is my understanding.
Well, let me play this out for you. It's, as I said, I have some familiarity with this immunity issue since I routinely see these motions. It's a very strong motion to dismiss. If that motion is filed and heard, again, an accusation is one thing, but it would seem like there's a little bit more. You'd have to have some
It's just
substance to it to actually disqualify him. But
Doesn't sound
I'll
like
keep
it.
an open mind on it.
It doesn't look like the way I imagine him sounding.
Anything more?
Anything else?
No, I read all your stuff.
Thank you.
Anything more?
No, sir.
Mr. Bradley, anything?
No, Judge, thank you.
Okay. Mr. Carney, Mr. Cosgrove.
All right, there you go. All right. He said Carney. I was like, what? What's happening? Oh my goodness. I think I might need to see Zach wiggle for me. What's the change to talk about here? But when you see the wiggle thingies, the wiggler the things going, I had to superimpose my face over Zach's.
Wiggle, 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 yeah. 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 Wiggle, 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 yeah.
Oh, did anyone watch Royal Rumble in Saudi today? No, but I did see that trending. I did see that trending. Thank you for gifting a membership, Strains. Zach Wiggle for the defense fund. Wiggles hurt my eyes. You're supposed to get an opportunity to rest your eyes. Oh my gosh, Zach's Wiggler just winked at you. That's talent. That's talent. So after that, I want to say that Better did a great job. It's always one of those things that's it's scary to watch, you know. It's because you want it to be like TV, you know. You see the TV attorneys, they know everything, man. They're so perfect at everything, right? Well, yeah, because it's all fake, it's all scripted. You think about this, like Beto's been practicing law for a very, very, very long time, and he wrote a very, very great memorandum of law, whatever the judge called it. And then the very first thing it sits down is the judge immediately starts attacking it. It's all a tactic. It's all a tactic. And you know, I don't know. It's the thing. Put yourself as a judge. Judges are just people. Well, if you were up there, would you do stuff like that before you started asking questions of law? Would you be up there? You know, because you want to see, like, oh, if I can knock them off their feet a little bit, you know, if they're not, it's a sucker punch, maybe. And it's like, can they come back from it? It was I don't know. It was very intense. I mean, I'll tell you right now, y'all, I can feel that anxiety enzyme or whatever it's called, you know, flowing through the body. But Better did an incredible job. I see why he's such a respected attorney. It's just like, man, I'm just glad it's not me. All right, let's do this.
If not, if you're conflicted out in one case, why aren't you conflicted out in the other? That's the real big question here.
Well, I don't think the two necessarily follow, Your Honor. Obviously, before I filed my motion seeking to withdraw in the other case, I would have been a poor attorney indeed if I didn't think about whether it also required me to withdraw in this case. And the motion to withdraw was, at least I attempted to phrase it quite carefully, to say that I had a conflict because Ms. Catani was the alleged victim in that case. Not that she was a witness in that case, but that she was the alleged victim. And as we all know, Your Honor, the Commonwealth does not represent the victim. The Commonwealth represents the Commonwealth of Massachusetts. But nevertheless, it was essentially an argument that I would be making in that case that Mr. Kearney committed crimes against Ms. Gattani. That, it seemed to me, put me in the impossible position of raising the suggestion that I was going forward to vindicate Ms. Gattani's interests, perhaps to mollify her or to persuade her to withdraw the action against me. That's not the case where she is simply a witness.
Well, what do you say to the idea that you'd want to discredit her for your own benefit if it came to trial?
Well, that's a very interesting point, Your Honor. And there's a couple of problems with it. One problem is the practical matter. I don't see how any way that I went about discrediting her testimony in this trial would spill over to the other litigation, because it doesn't seem to me that it would be in any way relevant to the other litigation. I suppose I could adopt the defense theory that everything is relevant to every issue, but I don't see how indicating that
everything is relevant to every issue. And the judge just asked, Bedro said, what if they don't ask that question? What if they don't cross the witness? Everything's relevant. Everything's relevant, man. It's just the way it be.
Ms. Gattani
You be
was
like
not
that, Mr.
credible in making statements about the investigation of Mr. Kearney here would have any relevance to an accusation that I breached some sort of duty to her by turning over a police report, which is the contention. Also, Your Honor, assuming that this even survives a motion to dismiss, and I'm talking now about the Middlesex case, I don't think there's any factual dispute.
Worcester case. There's nothing in Middlesex, right?
I'm sorry, Worcester, yes,
Okay.
thank you.
All right.
I appreciate the correction. I don't think there's any factual dispute as to what happened. In my
What just happened? What just happened? I like Dr. Pepper. I like the way it tastes. Mama Bug. So do you think he? Oh, I love this cat with the dessert warrior donut. That's the dessert warrior print. Sorry, I love that. Do you think he's talking about Turtleboy's empty? I guess motion to dismiss or colleague motion to dismiss the civil case with Lindsay. I have no idea. I am not very smart. I can't keep up with things like that. No, who would? Blackberry. I just realized something. That's why you got hit on by that smiling guy. Now I get it.
capacity as a prosecutor, I provided Mr. Bradle the police report in question as discovery. It made its way by whatever means from Mr. Bradle to Mr. Kearney, who then publicized details of it and turned it over to a friend, an associate, whatever you want to call him, who actually put the whole report, as I understand it, on the internet and began pillaring Ms. Gattani over her credibility. I don't dispute that I turned that report over as a matter of discovery. If if this case ever develops in Middlesex and comes to fruition, I couldn't possibly dispute that. That's the absolute factual truth. From that point on, it becomes a pure question of law as to whether I breached some sort of duty under the statute to Ms. Catani under the mistaken belief that I had a Rule 14 obligation to turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias.
What's he talking about?
Maybe I made a mistake. Maybe I was wrong legally.
Maybe I made a mistake. Maybe I was wrong legally.
That's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter.
How do we avoid the circumstance? But she's called to the stand, and there's some relevant testimony that she can offer. You wouldn't call her, but the defense calls her. And you're in the midst of cross-examining her, and she says, well, this is why I sued you. What do we do with that?
I'm not sure what you do with it, Your Honor. Maybe
hold on, wait
we deal with that with the motion.
I was watching Baker do sign language over here. Hang on a second.
To turn this over as the statement of a witness who had testified against Mr. Kearney in another matter, and as bearing on her credibility and her possible bias. Maybe I made a mistake. Maybe I was wrong legally. But that's not a matter of discrediting her. That's a matter that is purely a question of law. And it's also not a matter.
How do we avoid the circumstance? But she's called to the stand, and there's some relevant testimony that she can offer. You wouldn't call her, but the defense calls her. And you're in the midst of cross-examining her, and she says, well, this is why I sued you. What do we do with that?
I'm not sure what you do with it, Your Honor. Maybe we deal with that with the motion in limine to preclude her from mentioning the Middlesex suit.
Doesn't sound like a terribly controllable witness.
Well, that's why we have skillful Superior Court judges, Your Honor, if I could.
If you can find one.
What's this judge's name? We'll just say judge. So, Cosgrove. Judge says Cosgrove. Let's say the defense calls Catani up to witness, and you're in procedural matters, you're cross-examining her, and she says, and that's exactly why I sued you. How do you handle that? Well, I'm not sure. Possibly file a motion in limine. To get her statement precluded. I would think that what you do is, if you're cross-examining and the witness says something, and that's exactly what I'd say, I would object and I'd say, Your Honor, she's not answering the question. She's not answering the question. She's a hostile witness. No, I asked her, why did you sue me? She answered, she gave that, that's her own thing. I mean, come on, dude. Jeez. Oh, I don't know. I don't know, though. I don't do this stuff. Never have. I'm not an attorney. Don't do any of this stuff. But I mean, come on, man. Come on. So anyway. Then he says, well, that's why we have excellent Superior Court judges. And the judge is sitting there on the bench, said, if you could find one. Oh, don't do that. Don't do that. Angie, what's up? K-Ray, how you doing? Oh, jeez. All right, sorry, y'all.
Be a little obviously self-serving in my comment.
I'd be
I'm
self-serving
sure Your
in
Honor,
my
both
comment.
in his prior career, as I have in mine, and in your present position, has dealt with witnesses that are difficult to control.
What about the possibility of someone else coming in? Is that something that's realistic or not realistic?
I didn't quite hear you. Something else?
What about the possibility of bringing someone in to deal with Miss Gaetano if indeed she's a witness?
Could be done.
Well, it would solve a lot of issues.
So
Mr. Bedrow?
Said, just step
I mean,
down.
you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
Unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani. But if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard-pressed to figure out why the issue of the lawsuit would come out.
So wait a second. You're going to have...
Could. I don't...
Hold on. You're going to have you're going to have somebody else come in just in case she gets brought to the stand. And then you have to step down. She can still say at the same time, she said, well, that's why I sued Cosgrove over there. I mean, come on. This is police. You guys are messing with me, right? You guys are setting me up. This whole thing is you just set me up. I know it. This is not real. This is not real life. It is not real life.
Wiggle, 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 yeah. 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 Wiggle, 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 yeah.
T42. Thank you. You wiggle queen, you. Oh, wait, I missed one. Where'd I miss it? K-Ray, thank you.
Wiggle, 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 yeah.
I knew you were punking me. I knew it.
But that is my job to control what comes out. But so
Yes.
Legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation and why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we're having this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. So It would appear to me what you're saying to me is, if there was a replacement for that issue, that would resolve this problem.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility of Ms. Gaetani.
You'd agree with me that does happen in trials, not with some frequency, but
know what I missed.
it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a
Witness.
Could be done.
Well, it would solve a lot of issues. Mr. Bedrow? I mean, you're not contending that the case goes away completely. You're contending that he can't deal with Gaetano.
unless, Your Honor, I understand what Your Honor is saying, and it sounds at first blush that the idea that if there's some kind of ethical screen, for lack of a better term, that just keeps a separate wall between Mr. Cosgrove and Ms. Gaetani. But if the issue of the lawsuit comes out in any way, whether it goes...
Well, if he's not the one asking the question, I'd be hard-pressed to figure out why the issue of the lawsuit would come out.
It could. Again, I don't know.
But that is my job to control what comes out. But so
Yes.
Legally, let's think about it not from a witness point of view, but from a legal point of view. If Mr. Cosgrove is not the one examining the witness, I preclude that evidence because it's really not very relevant. I think we all agree.
Your Honor, I mean, look, it's certainly not for me to suggest what could happen. It's for the court to rule and the prosecutors to figure it out. I guess the first question is, why are we having this conversation, and why haven't they done that? Why is this a one-man show when this is a serious issue that there could be peril?
Well, that's why we're having this conversation.
Right.
Ahead of time, as you properly noted.
The other thing, if I could just respond briefly, I don't know if Mr. Cosgrove...
I think he's not done yet. I just was raising that one point.
I'll hold it.
Cosgrove has barely started, but go ahead.
All right. It would appear to me what you're saying to me is, if there was a replacement for that issue, that would resolve this problem.
I don't know that it would. It's certainly a much more realistic situation where you could avoid, no question, having Mr. Cosgrove comment on the credibility.
So wait a second. Cosgrove? Did he just call himself Cosgrove in the third person? Oh my gosh, you know what he sounds like? Have you guys ever seen Seinfeld? I never saw Seinfeld until like I was with White Rabbit. And anyway, I'm a big fan of Larry David. I'm a big fan of Curb Your Enthusiasm. And I didn't know that Larry David played the Steinbrenner character, and George Steinbrenner, you know, the owner of the Yankees, he's dead now, but anyway. And that's what it sounded like was Larry David's interpretation, him doing Steinbrenner's like, Cosgrove doesn't know if he wants it. Steinbrenner really likes the sandwich. Really, he calls himself out in the third person. Expert thinks it's funny when people talk about themselves in the third person. Expert really likes gummy nerds. How do I start this thing?
Of Ms. Gaetani.
You'd agree with me that does happen in trials, not with some frequency, but it's not unheard of for that to happen.
No, it's not unheard of at all. I mean, there are times, again, where you have a prosecutor who takes a statement of a defendant.
Sure.
They have to be a witness, these kinds of things can happen all the time.
We find ways around them.
But we're also, to be clear, we're dealing with a very rare situation where the witness is a former prosecution witness accusing the prosecutor who she testified for previously of misconduct. Now, if the prosecution and the court approves of that process, wants to have that laid bare, then I suppose it could. But the other problem, just
on this issue, we're not going to hijack the rest of the argument.
Okay,
just on the issue of replacement.
I had a brief response.
Yeah, he's not done. You only get to respond when he's done.
Yes,
Mr. Cosgrove.
Well, just on that point, I had
Wiggle, 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 yeah. 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 Wiggle, 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 yeah.
yet to hear how any comment that I might make on the credibility of Ms. Gaetani's testimony in the case before the court would even come in or be relevant in the Middlesex case or assist me in any way. Am I going to go over to Middlesex Superior Court and, frankly, I find it hard to believe that I or whoever would be representing me would be brazen enough to say to the judge, well, I want to talk about all the ways in which my client, Mr. Cosgrove, impeached Ms. Gaetani in a case that has nothing whatsoever to do with the case before the court. There's just not going to be any bleed through whatsoever, it seems to me. We don't even have, frankly, Ms. Gaetani's now at the point, based on her public statements, where she has faced in so many different directions, that I find it a little difficult to believe that either the Commonwealth or the defense is going to call her in this case.
Cosgrove says Cosgrove isn't going to do it.
Counsel has carefully said we may call her for the defense. This may be a contingency that doesn't even arise, but that's sort of a side point. Let me just take a couple of points. I was going to ask Your Honor to take.
Hang on a second. Angie!
Wiggle, 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 wiggle.
Well, I lost the screen. I was over there in the other place. I didn't know what's going on. Cosgrove can't figure out what Cosgrove wants to say next.
Take judicial notice of the pleadings in the Middlesex case and the docket. It appears you've effectively done that, but let me make an oral motion on the record.
Any objection, Counsel?
No. Purpose.
Okay. Agreement. I'll take those as judicial notice as to the Worcester Superior Court case.
And one of the interesting, unique things about this alleged conflict of interest, which is a little different from the typical conflict of interest case, at least I haven't found anything precisely on point, and I don't think the defense has either, but maybe they'll prove me wrong in a moment, is the whole operation by which this alleged conflict has come about and the Middlesex case has come about. What is it that enables Ms. Gaetani to make the claim that she's seeking to make against me in the Middlesex case? It's that defendant took the report I gave him as discovery, or I gave his counsel as discovery in the other case, publicized it, and then created the harm that Ms. Gaetani alleges accrued to her from that publication. In other words, if we're applying but-for causation, to sound like a tort lawyer for a minute, if we take Mr. Kearney's actions out of the whole proceeding,
I got a buddy of mine.
There's no harm whatsoever to Ms. Gaetani with my, as I see it, fulfilling my Rule 14 obligation. So Your Honor has the unusual situation here of a defendant who has been
Cosgrove's but-for defense.
But-for cause of the alleged conflict, seeking to profit from that conflict by removing the prosecutor of his case, which I think is is worth some consideration by the court. What I would like to do now, Your Honor, since the defendant has had the opportunity for a reply brief, which frankly doesn't particularly go to these motions, particularly, but more to the point, the defendant's reply in support of the motion to disqualify Robert Cosgrove. I'd like to examine that in some detail and take the opportunity to reply to some of his.
Well, it really hasn't become an issue here. That involves another party whose case has been dismissed. The case regarding the defendant and that witness is gone. That's dismissed. So I don't really know if that's all that relevant to any. Mr. Bedore didn't even raise it.
For purposes of this, Your Honor, the briefs are what they are. We submitted them. I just raised the issues I thought would be helpful for the court today.
Yeah, I didn't find that anything with regard to that particular trooper terribly compelling because I don't understand how he would be part of this case. Fair to say?
You're talking about which trooper?
The trooper whose case was dismissed, Bouchard.
I'm not talking about the. I'm sorry for interrupting, Your Honor. I'm not talking about the motion that they filed with respect to discovery for Mr. Proctor.
Oh, I'm not dealing with discovery right now. Yeah.
I'm talking about the motion that's captioned, "Sir, reply in support of motion to disqualify Robert Cosgrove."
Paper 127 you're talking about.
I don't know the number, to be honest with you, but
this one here?
yes, exactly.
That's 127.
Okay.
Okay, go on, I'll hear you.
All right. So, the defense begins by complaining that my response envisions my conflict in a vacuum, and that it ignores the whole context, which is basically a preface, Your Honor, for talking about everything else that the defense is unhappy with about the case, except issues that are relevant to whether or not I should be disqualified. There is, on page 1 of that motion, a suggestion that Mr. Morrissey recused his office from prosecuting Mr. Kearney due to a conflict created by an investigating journalist who publicly accused the DA's office. I'm not sure that Mr. Morrissey has made a statement explaining why he appointed a special prosecutor, but I'm ready to stand to be corrected, but certainly this is the explanation that might sound most favorable to the defendant, but what does it have to do with disqualifying me? He then talks about accusations against Lieutenant Tully and former Trooper Proctor and Sergeant Uri Buchanan. What does that have to do with disqualifying me? He talks about actions by Sergeant Buchanan.
Disqualifying you, it goes, 1, you withdrew to begin with, and 2, you have a lawsuit against somebody who's important to the whole case. Like, here's the thing, bud. Like, this is for your benefit. Like, you're not coming in here as a prosecutor with clean hands. I mean, now we have this hearing. If Cosgrove gets to be the prosecutor in this, it's with it looks suspect. I mean, this is not. Am I the only one that thinks that? Am I the kid wandering into a movie when it's already started and asking what's going on? Oh, well, I am because I'm late to all this stuff. I'm new to all this. I answer my own question. Expert answered expert's question.
Taken after he left the Norfolk District Attorney's office in support of a legal civil dispute between Ms. Reed and the alleged victims in this case. That has nothing to do with whether I should be disqualified. We've talked about my voluntary withdrawal from the indictments concerning Ms. Gattani. And if Your Honor would take a look at page 6, where we have bullet points. All right. The first bullet point is absolutely relevant, and that's what we've talked about, that I'm being sued for intentional misconduct by Ms. Catani. And we hear that Lieutenant Tully is being sued by Ms. Catani. So what? The Detective Tully has been sued by Karen Reed. What's that got to do with the price of beans, as they say? That there were disciplinary proceedings.
Who are they? Who are they? Because this thing I've always heard, what does that have to do with the price of tea in China? What does that have to do with the price of beans? That's Jack and the Beanstalk. And a cow is worth 3 beans.
Against Lieutenant Tully.
That might be relevant on cross, you'd agree?
Oh, yeah, it might have some relevance on cross, but what has it to do with disqualifying me, Your Honor? They weren't disciplinary proceedings
Fair point.
against me. We hear that Ms. Reed is suing Sergeant Buchanan. Well, good luck to Ms. Reed, but what has it to do to disqualifying me in this case? We hear that Buchanan was disciplined. That Proctor's been sued by Ms. Reed. That Proctor has had disparaging text about Ms. Reed. There are 2 things that the upcoming case should not be about, Your Honor, and I'm sorry I'm losing my voice here, excuse me. One, it should not be a trial of the case that has been null pros concerning Ms. Gattani. And 2, it should not be a retrial of the Karen Reed case. None of this stuff is relevant. Gattani's testimony will undermine the credibility of Detective Lieutenant Tully and Ms. McCabe.
None of this is relevant. It shouldn't be a retrial of the Karen Reed case. You're trying the guy for witness intimidation in the Karen Reed case. It most certainly is relevant. It's 100% relevant. It's 1,000% relevant. Expert thinks the expert's right when he says it's relevant.
Which will subject her to cross-examination by Mr. Cosgrove. Now, let's look specifically, if I can skip ahead in the memorandum. The argument that's been made a little later on in the memorandum, in which Your Honor has heard again today. And I'm looking now at page 60.
100% agree with this. I could go down a whole thing about me facing your accusers. Anyway, Tully's the lead investigator, and they are both being sued. Aiden has the right to face his accusers. And, you know, it's funny because it almost feels like this is being treated like a civil case when, I mean, if they wanted, I think the remedy may have been civilly, you know, instead of witness intimidation, you sue for defamation, maybe. I don't know. But it's criminal. I mean, criminal is a whole different set of rules and everything. And yeah, he has 100%. He has the right to face his accusers. And there she is. Diane G, what's going on? Oh, wait a second. Here we go. Look, this is for all you beautiful people up there in the great Commonwealth of Massachusetts.
Your Honor, the first full paragraph. Ms. Gattani will testify that Detective Lieutenant Tully intentionally mishandled her cell phone by tampering with and or deleting its contents. Detective Lieutenant Tully will deny this. Mr. Cosgrove has accepted Detective Lieutenant Tully's explanation without any further investigation. Well, I don't know how the defense knows that I've accepted Detective Lieutenant Tully's explanation without any further investigation. But let's put this on a timeline. It has been the contention of the defense from the start of the case that certain items were missing from the download of Ms. Gattani's cell phone. And their explanation is that must be because Detective Lieutenant Tully deleted it. I responded to that. Ms. Gattani is a latecomer to this discussion. She is only now, in the form of either public statements or representations by the defense as to her new position, suggested that this is because Detective Lieutenant Tully tampered with it or deleted its contents. By the way, I don't know how she would know that because she was not there during the download of her cell phone and the transfer of it. But at any rate, my response as to what happened to the cell phone.
Oh my gosh, he sounds
occurred
normal.
Before Ms.
He
Gattani
sounds
made
normal.
any of these statements whatsoever. I don't know how it can be that I have been siding with Detective Lieutenant Tully over Ms. Gattani. I haven't seen an affidavit from Ms. Gattani. I haven't seen anything from Ms. Gattani other than hearsay, which is just a representation. And certainly, but let's assume that I do, as they put it, side with Detective Lieutenant Tully in cross-examining Ms. Gattani and in the closing argument. What does that have to do with defending my position in the Middlesex case, and how is it relevant, and how would it even be introduced? I have no idea. Let me back up and make a couple of other points.
Oh my gosh, we're
I want to
backing
turn
up.
to the legal argument, say a little bit about the law.
Expert doesn't like
And
backing up.
I suspect Your Honor has probably already looked at the two cases cited by Mr. Betterow, Commonwealth versus Dunlap, and the other case is named USB Health, which involves a complicated civil action involving the Church of Scientology and others. The first thing to say about these cases
Church of
is that
Scientology,
Pennsylvania
don't
cases,
mess with
Massachusetts
them.
cases,
Cosgrove.
at best, I would say they are persuasive authority, not binding authority.
I don't think Ms. Betterow contests otherwise.
The second thing I would say is that
He's
they are both
he's falling
opinions
asleep.
in
The
which
judge
the
is
court
falling asleep.
declined to rule for the defense on the conflict of interest argument. In the first case, Dunlap,
I said
the
hello as
decision
soon
of the
as you
Superior
came
Court judge
in.
was affirmed by an equally divided court.
Angela said hello as soon as you came in. I said,
The dissenting
Angie!
justices characterized the other side as the majority, but the opinion itself says that the appellate court was equally divided. So I'm not sure if it's even good as a dicta. It seems to me it has no precedential value at all, but if it does have precedential value, it was a ruling in favor of the Commonwealth. And what were the facts? In a sentence from the dissent, that is, those who believe there was a conflict of interest, the district attorney who prosecuted this case also represented the victim in a civil suit arising out of the same transaction. That is a mile away. That is a stadium away. That is a continent away from the facts in this case. I am certainly not representing Ms. Gattani in a civil suit arising out of the...
Does he know that usually you do things in increments? You don't go like, that's a mile away. It's a stadium away. That's a continent away. Oh my gosh, look at Baker. Oh my gosh, I couldn't have paused that at a better time, could I? I've seen that look in real life.
Events that bring the defendant into court. Now let's take a look at the health.
I was trying to figure out what he was drinking.
Which is the federal case. That does have some interesting parallels to this case. According to the decision, and I apologize for not having the pin sites, but I think Your Honor will readily find them. The defendants contended on appeal that they were denied due process because two prosecutors were defendants in a civil action filed by the Church of Scientology 10 days after the events that went down in this particular case.
Don't mess with Tom Cruise,
and they alleged,
dude.
And the events that went down were a search of the Scientology's office in Los Angeles, and they alleged that the raids were conducted in bad faith
how you
with
doing?
the intention of violating Scientology's constitutional rights.
Oh, I gotta eat some.
You can look back at the memos filed by the defense, and the contention they're trying to make, or one of them, is that this is a bad faith prosecution. So that applies here. What is different here is the civil suit apparently precedes the raid that the prosecutors make in the defense office in the Church of Scientology. Here, there's nothing like that. The events that the defendant was charged with in this case occur before any involvement by Ms. Gaetani, before any involvement, by that matter, with me. And those issues are pretty well set, and they have consistently been followed through. Now, here's another similarity between Height and the current case. I'll just read a sentence or two. The government contends that prosecutors cannot be disqualified when sued by a defendant, because defendants could then remove whichever prosecutor they please simply by suing him. Now, of course, the defendant isn't actually suing me here. He's simply seeking to profit from a witness suing me. But certainly a suit by the defendant would be a much more direct potential conflict. I have not gone so far as to represent to the court that I cannot be disqualified when sued by a defendant or by Ms. Gaetani. I think in fairness, the court can look at it. But
Melissa!
The argument was that any suit
we have a Melissa
complaining
Jane.
of an action taken in contrast, in a prosecutor's quasi-judicial capacity would be frivolous and non-disqualifying because he enjoys absolute immunity as a prosecutor. Cite to a U.S. Supreme Court case. I believe as Your Honor reads through, we'll find that the court in Height pretty much bought that argument. And they go on to say that appellants have made no credible claim of actual prejudice based on the prosecutor's alleged pecuniary or personal interest in the outcome of this prosecution. I certainly have no pecuniary interest in the outcome of this prosecution. I have no personal interest in the outcome of this prosecution. And nothing in this prosecution is going to affect anything that's going on in Middlesex.
It's not Middlesex.
Worcester Superior Court, Your Honor.
Understood. Any further? From Mr. Cosgrove, sorry.
No, I'll stop at that point, Your Honor.
Mr. Bedrow.
Yes, thank you, Your Honor. We might as well start from the back with U.S. v. Health, Your Honor, which is 668 Federal 2nd, 1238, the D.C. Circuit, 1981. Mr. Cosgrove has buried the lead about Health and about Dunlop. Those were appellate arguments post-conviction. So that is a huge distinction about a timely motion in advance, raising issues which could lead to a conflict. We all know that raising a conflict on appeal, when you could have raised it before, is looked at in an entirely different way. And the relevant language from Health that I would direct the court to is on page 1276, which states, given the need to promote the appearance of justice, a trial court on timely motion, to wit, like here, should disqualify a prosecutor from participating in a criminal action when he has a personal conflicting interest in a civil case. That's here.
Well, the key words there are alleging bad faith. I'm not sure that there's an allegation in those other complaints of bad faith. There's an allegation he violated the statute. I'm not sure where it talks about bad faith.
Sued him for intentional infliction of emotional distress.
Negligent infliction. There's a difference.
She sued for intentional.
I read negligent, but I'll go on.
Respectfully, Your Honor, there are deliberate allegations of intentional misconduct in the complaint, but that's, the court can obviously go back and one of us.
We took judicial notice.
Exactly.
So
one of us is right.
I read this morning as negligent, but that's.
I don't think that's how you take judicial notice.
Your Honor.
Man, that's not how you take judicial notice. Judicial notice is it's a fact. It's just he's arguing. The two guys, the judge and the attorney, are arguing about what's in a case. Oh my gosh, I've never seen an attorney argue like that to a judge, though. Think about that. Oh man. No.
Conviction. The other issue, and I want to go back to the beginning that Mr. Cosgrove started with, he illustrates the whole problem here. He's defending himself, and I have no opinion on the merits of Ms. Gaetani's claim, okay? As a lawyer, I sympathize. But he started by telling you that this case is going to get dismissed, and all I did was turn over this. He is illustrating front and center his personal interest, that Gaetani is accusing him of things he didn't do. And the conflict, the personal interest, isn't the outcome.
She's not accusing things he didn't do. He acknowledged he's doing.
But he's justifying it and saying she's trying to do this, she's not credible. The point is this. The personal interest for Mr. Cosgrove is not whether he was wrongfully sued or whether it has any merit. His good name has been attacked. And like anyone else, he has an absolute right and a personal interest in defending himself. And again, the proper forum to do that is not while prosecuting a case in which his accuser is a witness, his co-defendant is a witness, and Ms. Gaetani is going to probably impeach, assuming she's allowed to, their star witness, Ms. McCabe. When someone's integrity is
assuming
attacked,
she's allowed
they have
to.
a personal interest, especially someone as credentialed and respected as Mr. Cosgrove. We all understand that as lawyers and judges, but that doesn't mean you get to prosecute the case. That's for you to decide, obviously. And we're talking about an appearance. If this looks terrible, which leads to my next point. Mr. Cosgrove went through all of these allegations in our papers about, Proctor had this, Tully's been sanctioned, Buchanan, it's literally aligned with Jennifer McCabe,
we're gonna have
wrote
so
about
much fun.
supporting her. Buchanan was a witness in this case too, and part of the investigation.
But not anymore.
No, but the point is this. He is looking at this in a vacuum. The public must have confidence. Part of the analysis
Yes.
of
Oh,
a
that's a
conflict of
great way
interest
of
is the
wording
first sentence of the brief that he just cited from, is that the public must have confidence in the criminal justice system. And this latest
That right there, I would ride that out. If I were Turtleboy, I'd use that line the entire time. The public must have confidence. And do they have confidence? I mean, after Karen Reed 1, Karen Reed 2. Does the public have confidence in the judicial system here? Oh my gosh. Excuse me. He says it perfectly here. In the criminal justice system. Is there public confidence in the criminal justice system of I don't know, Middlesex or Overton or Cotton Eye Joe County? I don't know. I can't remember now. Where are we? Are we still in Massachusetts? One of those M states. We might be in Montana by now.
conflict is a pile on conflict after conflict after conflict in this case. And if the cherry on the sundae,
but let me slow you down, because we're conflating two different issues. I'll agree with you. There's all sorts of issues that have developed over the course of these interrelated prosecutions. Mr. Cosgrove's role, though, is a latecomer and really had nothing to do with any of these other issues. So I can't sit and say I impute all of those other things to Mr. Cosgrove. And therefore, if we look at that mass of problems that have developed, he's out. Because the same logic would say the next person who sits in that seat, the same argument would apply.
let me be very clear. I'm not accusing.
I didn't take it that you were.
Fair enough.
But my point is, all of those things are conditions which are already present in this prosecution.
They are.
So really the only thing dealing with is this issue, because the rest of those things he had nothing to do with.
Well, one of them, he had his other conflict, which he voluntarily sought.
But that came out of the same exact issue.
Yes. Well, that's our point. We think it's the same conflict.
I agree with you. But the point I'm trying to draw, and the distinction is, all of these other
Should a
problems
judge make a
that
point
arose out of
like
the Reed
this?
prosecution, real, imagined, substantial, that's really not for me to decide, right? They're all out there, all right? And they're all going to be there no matter what. So whoever sits in that chair right there is going to have all of those problems.
Difference, I don't mean to cut you off, Your Honor. The difference is that if it's not Mr. Cosgrove, the man or woman who would be sitting in that chair is not being sued by Ms. Gaetani and co-defendants.
That's my point. That's the only thing I have to analyze. Okay. That point.
Our point, respectfully, was that given the public's need for confidence in this case, not the Karen Reed case, that's a whole nother conversation for someone else on another day. But this case is filled with conflicts, and I don't think we can all just avert our eyes to and say, but none of that matters, but we're going to have a prosecutor now cross-examine his accuser and then say she's not credible. He also indicated, Your Honor, they're not even calling Ms. Gaetani. I can't fathom how that might happen. They use careful language. They may call her. We're the defense. We don't have to do anything. We can take a nap throughout this trial. And there may be such a terrible joke of a case they present that we stand up and rest. So, of course, why would any credible, serious lawyer commit a year in advance? I'm calling this witness. We're alerting Mr. Cosgrove to what we think is his conflict in the court, and we may very well do that. The last point for this, he said there's no affidavit from Ms. Gaetani, or it's all just hearsay about, tampering with her phone. The best basis for that will be the posting online social media by a third party and long-time known critic of Mr. Carney of messages which did not appear on an extraction report that we got from Tully of Gaetani's phone, and then we never got anything from Tully's phone. We got screenshots of what he claimed were messages. That's the basis for that. Thank you.
Fair enough. All right. So here's what we'll do. I'm going to set another date. Let me talk about this. Mr. Brady, when we selected we penciled in the trial date, I gave you a very long date, longer than I wanted.
Do we need, is there any ruling or anything today? Or is this it? Do they keep going?
Your schedule, has it changed? Can we get this thing done earlier? Assuming it's alive?
Judge, it's probably gotten worse.
All right, well, we're not moving the case back. That trial date's not going to go backwards.
Is that on here?
No, this is a 2023 case. It's 2026. It's not going backwards. If anything, it's going to move forward. So don't.
I know you'll relate to this, Judge. I have the usual slate of like fall murder cases.
I get it. But this one's an old one. And
I don't have the press conference on here.
I was going to try to move you forward. But if you tell me that can't happen, then that can't happen.
I'm sorry.
All right, but understood. This court is willing to take this case much faster than the current schedule.
We do have a few other pretrial matters to address. Your Honor mentioned the motion to dismiss. Maybe we should schedule that.
What we're going to do is this. I'm going to take this under advisement. We're going to pick a date right now. And either we do a motion to dismiss that day or we're on for appearance of new counsel that day. All right? One or the other. We're going to know. I'll get you a decision beforehand. Now, I am open to the idea that if I accept there's a conflict here, I haven't made that determination yet, but if I accept there's a conflict, I'm open to the idea that it's resolvable by having someone else step in and cross-examine her. I think that solves all of the issues.
No, it doesn't.
That might be the easy way here, so everybody can get this thing moving and have this trial, which all parties seem to desire.
So just on that point, I appreciate you kind of reflecting your thought process. But even if counsel stays on the case but doesn't actually do the questioning, it still remains that there's a conflicted counsel on the case. And the
Mr. Bradley, you and I both know that
interest.
Mr. Bradley, you and I both know this happens with some frequency, and we work our way around.
We just shouldn't.
Right? The jury's concentration in this case is on events of the case. Now, Ms. McCabe's credibility, I expect to be a robust cross-examination based on all the information that you've gathered. And if it's appropriate to bring in an extrinsic witness, and generally, as you're well aware, it's not. If it's appropriate to have an extrinsic witness on that issue, then we'll take that as we go. But
I may hit that up tomorrow.
Mr. Cosgrove raises a reasonably good point.
I'll do
that there's been some recent case law talking about the police can't create their own exigency.
Press conference.
And to some extent,
2 hours.
The defendant has created his own exigency here, because in fact, the plaintiff in that case, is suing because the contents of her phone were put on the internet. The defendant did that. So there is some, you got to be fair to both sides here and say this is something which only happened because of steps taken by the defendant.
Well, Judge, I don't want our lack of
why only by steps taken by the defense
response to that to be perceived as an acknowledgement. I don't want to address that.
I'm basing that simply on what I read in her complaint. Not anything's been represented to me today.
Right, exactly. And so just a couple of rewinds here, Judge, is that the government themselves, in Lieutenant Tully's own affidavit at the time of this, back in December of 23, swore in the affidavit that Ms. Catani was a witness in the matter. And so I don't think the government can do a 180 and say, oh, she's not really a witness.
Well, she's a witness, but she was a witness at that point. They were trying to indict your client for some sort of conspiracy charge, which failed.
Right.
All right, and the grand jury didn't
live and under investigation.
Well, that's another matter. I've told you I can't.
You got to accept judicial notice of it. I mean, hell and fire. If you're going to, never mind.
Authority to affect that. What I do know is that was no build.
No build.
Even worse. Okay,
Yeah,
that was no build. So I can't imagine a circumstance where I would allow evidence in about a no build issue. I remain to be persuaded on that. But
so what? And just to go to the lowest hanging fruit on why Ms. Catani would be a witness, there's all sorts of screenshots and text messages, and we need these things authenticated before we use them.
I'm not necessarily saying that can't happen.
There's all sorts of reasons.
I get that, but
no one's trying to trigger a recusal. There's a lot of good reasons why she's involved in this. The government's own affidavit.
I'm not discrediting what you're saying. What I'm saying to you is, I think there's a way around this. And I don't know that the closing argument is going to change that, because the closing argument is based on what's heard at the trial and, I'd add, in this court's view, and in the proper practice would be confined strictly to the evidence that's presented before the court. So, no, it's not going to.
I appreciate your reflections, Judge. If I could just have one moment.
Yeah.
Thank you very much. That's all we have. And just
let's pick a date.
are you late February, March, okay, early March? What would you like, Your Honor?
Let's go later in March.
All right, March 27th?
Is that Friday? Fridays are generally best.
I can do that.
It is a Friday.
Do it on Friday.
Thank you.
I don't know if we'll be in this room. I'll have to consult with the occupant who has generously lent me this
What
room
are they
today.
doing on the 27th?
I want to say one other thing, if I could,
Sure.
Your Honor.
Oh, geez. Spit it out, cause.
I am concerned that the protective orders that have been issued by the court have been the subject of violations. I'm not prepared to address it today, but I want to put defense and the court on notice that I do think there's a basis for that argument, and I will plan on raising.
What the hell does it have to do with
Raise it
this?
first with the other side.
This
so
is,
that you're, they're
this
aware of your
is
concerns.
so typical.
Oh, of course.
All right.
This
If it's not
case,
resolvable, then the court will step
they
in.
just bring up all this outside
benefits.
stuff. I mean, just stuff. Lack of a better term, it's just outside stuff. It's like, oh, wait, we got this. It's like, oh, look, we're gonna paint this person as a complete ass.
Way this
You
court looks
know,
at this
everything they've
is
done
this
is
is
wrong.
an
They
important
ran a
issue
stop sign on the way
which should
over
be decided by a jury of the defendant's peers to decide the mores of our society, whether or not this is journalistic activity or it's not journalistic activity. Let's try to focus on that, folks.
I absolutely agree with that, Your Honor.
Okay. All right. Anything else we can do today?
Oh, sir.
March 27th. The purpose of that hearing to be determined, but could be one of those two things.
Thank you.
Thank you very much, Your Honor.
All right.
Your Honor.
All right, both matters continue to March 27th.
Well, thank you, Brother Bayer. Y'all, he's pinned at the top. If you're not subscribed to him, please go subscribe. And also make sure you're still subscribed here. They have a tendency to float away. J7, then why are you bringing it up? What did I bring it up? Did I bring it up? Oh, motion to dismiss or okay. We will not have a ruling until March 27th. I mean, the judge isn't going to go have another court hearing to say, like, okay, dismissed. Anyway, guys, listen. Oh, he probably is. He probably is. That's happening right now. That's happening right now. J7 knows how to get me. Look at that. Not one, but two. Very nice.
I think we got a super chat. I think we got a super chat.
Aw, the expert.
Thank you, J7. Thanks for giving me all this stuff. She's been a great help, a great source of knowledge. Strains has too. Everybody, you guys, you send me stuff. I appreciate you. You have to realize I don't have time to see it all. I try to. It's hard, man. This is so crazy, but that was interesting. And tomorrow, I'm gonna do tomorrow. I'll cover that the press conference afterwards. That'll be fun. I did see parts of it. There you go. No, Valhalla's the GOAT. Valhalla is, isn't he? Wait, hold on. Where'd he go? Valhalla. Valhalla's the GOAT. Oh my gosh, guys, thank you so much. Hey. Yeah. Oh, hey, that's what's guys, I'm actually sending you over. MG's doing a game stream here in a couple hours. So if you want to go partake. And anyway, on that, I love you guys. Thank you so much. Let's keep on having fun. Let's keep on having fun. And I'll golly, that's a lot to take in. I'm gonna go visit my wife.
Well, I woke up to go get me a cold pop. And then I thought somebody was barbecuing. I said, oh Lord Jesus, it's a fire. Then I ran out. I didn't grab no shoes or nothing, Jesus. I ran for my life. And then the smoke got her. I got bronchitis. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time. Ain't nobody got time. Ain't nobody got time for that. Well, I woke up to go get me a cold pop. Then I thought somebody was barbecuing. I said, oh Lord Jesus.